Question 486. Joni owns and runs a small clothing store. After a client sustains serious injuries when she slips and falls on a wet floor in the store, the client sues Joni and the store and wins a judgment in court. The client will likely be able to collect on the judgment. A. Against Joni and the store. B. Against just Joni. C. Against just the store. D. Against the city for failing to properly regulate Joni's property. Correct answer is A. Against Joni and the store. Based on the description, Joni owns and runs a small clothing store. It's highly likely that the store is a sole proprietorship. In a sole proprietorship, there is no legal distinction between the owner, Joni, and the business. They are considered the same legal entity. This lack of legal separation means that Joni is personally liable for the debts and obligations of her business, including legal judgments. The client sued Joni and the store, and won a judgment against both. This explicitly makes both Joni, as an individual, and her business liable for the amount of the judgment. The client can then pursue collection efforts against both the assets of the business, e.g., store inventory, bank accounts held in the store's name, and Joni's personal assets, e.g., personal bank accounts, other property she owns. The city's role in regulation does not typically extend to bearing financial responsibility for injuries sustained on private property due to the owner's negligence, in this case, the wet floor. The liability lies with the property owner and operator. Question 487. In signing an agency listing with a particular agency, the owner agrees to the following. A. Pay a commission to the agency if the agency sells the listed property. B. Pay a commission to the agency even if the owner sells the listed property himself. C. Pay a commission to the agency even if a different agency sells the listed property. D. Both A and C. Correct answer is D. Both A and C. When an owner signs an exclusive right to sell listing agreement with a real estate agency, they enter into a binding contract with that specific brokerage. A key element of this agreement is the owner's commitment to pay a commission to the listing agency under specific circumstances. A. Primarily, the owner agrees to compensate the agency if the agency itself successfully procures a ready, willing, and able buyer for the property at the agreed-upon terms or at a price acceptable to the seller. This incentivizes the listing agency to actively market the property and work diligently to find a suitable buyer. However, the exclusivity of this type of listing extends beyond just the listing agency's own efforts. The owner also agrees to pay the stipulated commission to the listing agency even if the property is sold through the efforts of a different real estate agency during the listing period. C. This recognizes the listing agency's sole right to market the property and ensures they are compensated for their time and resources invested, regardless of which agent ultimately brings the buyer. This provision is a defining characteristic of the exclusive right to sell agreement, providing the listing agency with the maximum protection for their commission. Under an agency listing, the seller has the right to sell the property himself without paying any commission. Question 488. Most lenders apply the C's test to screen loan applicants, which include A. Character, B. Capacity, C. Collateral, D. All of the above. Correct answer is D. All of the above. Character refers to the borrower's honesty, reliability, and credit history. Lenders want to know if the borrower has a history of repaying debts on time and responsibly. Capacity assesses the borrower's ability to repay the loan. This includes factors like income, employment stability, and debt-to-income ratio. Lenders want to ensure the borrower has sufficient income to comfortably cover the loan payment along with their other financial obligations. Collateral refers to assets pledged as security for the loan. If the borrower defaults on the loan, the lender can seize and sell the collateral to recoup their losses. Not all loans require collateral, but it can be a factor for some loans, like mortgages or auto loans. If one of the components is not at an acceptable limit or if there is excessive layering of risk across these components, the mortgage will likely go unapproved. Question 489. The phrase, "it goes with the land," most aptly describes an A. Appurtenant easement, B. License, C. Homestead right, D. Contract. Correct answer is A. Appurtenant easement. An appurtenant easement burdens one piece of property for the benefit on another, such as a driveway to the street for Lot A, dominant tenement, that crosses over Lot B, servient tenement. This type of easement runs with the land, i.e., if either the dominant tenement or servient tenement has a transfer in ownership, the new owner receives the benefit, or takes on the obligation, of the easement. Question 490. A franchise agreement establishes an agency, by which the franchisee is the agent of the franchisor, B. Employment arrangement, by which a franchisor treats a franchisee as an independent contractor. C. Legal right to operate a business under a common name and marketing plan, D. Both A and C. Correct answer is C. Legal right to operate a business under a common name and marketing plan. Although a franchisee operates under the franchisor's brand, a typical franchise agreement generally does not create a true legal agency relationship. In most cases, the franchisee lacks the authority to contractually bind the franchisor. A franchise agreement explicitly establishes the franchisee as an independent business owner, not an employee or an independent contractor for the franchisor in an employment sense. The franchisee owns and operates their own business using the franchisor's system. Therefore, the core of a franchise agreement is the granting of a license or right to use the franchisor's brand, operational systems, and marketing strategies in exchange for fees and adherence to certain standards. There is no employment relationship, and while there's a brand representation, it doesn't typically equate to a formal legal agency where the franchisee can act on behalf of the franchisor in a broad contractual sense. Question 491. All of the following statements about the escrow process are false, except A. Only a broker can be an escrow officer, B. The escrow officer acts as an arbitrator of disputes between the real estate commissioner and the buyer. C. An escrow is completed when the escrow holder is appointed, D. An escrow agency changes from a dual agency to a separate agency when the escrow requirements are satisfied. Correct answer is D. An escrow agency changes from a dual agency to a separate agency when the escrow requirements are satisfied. In California, escrow services can be provided by licensed independent escrow companies, title companies, banks, and sometimes real estate brokers under specific conditions. A broker is not the only entity that can act as an escrow officer. The escrow officer have no role in arbitrating disputes between the real estate commissioner, a regulatory body, and a buyer. The appointment of the escrow holder marks the beginning of the escrow process, not its completion. Escrow is completed when all conditions are met, documents are recorded, and funds are disbursed. When escrow is first opened, the escrow holder acts as a dual agent, owing fiduciary duties to both the buyer and the seller. They follow the instructions provided by both parties in the escrow agreement. Once all the conditions and requirements of the escrow agreement have been met, e.g., funds deposited, loan documents signed, contingencies removed, the escrow holder's role shifts. They then act as a separate agent for each party in carrying out the final steps of the transaction, such as disbursing funds and transferring the deed. At this point, their duties become more specific to each party to finalize the transaction according to the previously agreed upon terms. Question 492. Gift deeds conveying title to real property can sometimes be voided by A. The grantor's debtors, B. The grantor's creditors, C. Holders in due course, D. The state. Correct answer is B. The grantor's creditors. To evade creditors from attaching their assets, sometimes debtors will convey real property to friends or relatives by gift deed. Under these circumstances, there are legal safeguards which can enable creditors to have such gift deeds invalidated in court. Courts can set aside such transfers if it's proven that the transfer was made to avoid paying legitimate debts and rendered the grantor insolvent or unable to meet their financial obligations. Question 493. A second trust deed is distinguishable from a first trust deed by A. The title company, B. The date and time of the recording, C. The agreement of the parties, D. None of the above. Correct answer is B. The date and time of the recording. While the title company is involved in both the issuance of title insurance and the recording of the trust deeds, the title company itself doesn't inherently distinguish between a first and second trust deed. They simply process and record the documents as instructed. The agreement between the borrower and the lender will specify the terms of each loan, but this agreement itself doesn't legally establish the priority of the lien. The recording process does. While the parties intend for one to be primary and the other secondary, it's the public record that definitively establishes this. In real estate financing, the order in which trust deeds, or mortgages, are recorded establishes their priority. The first trust deed recorded creates a first lien position, meaning it has the first claim to the property in the event of foreclosure. A second trust deed recorded later creates a second lien position, subordinate to the first. A first trust deed takes precedence in the case of foreclosure, meaning it gets paid off first from the proceeds of the property sale. A second trust deed is a subordinate loan that only receives payment after the first trust deed is satisfied. The agreement between the borrower and lender will outline these priorities. Question 494. Prohibiting the posting of a for sale sign on a property in a particular neighborhood is A. Not allowed, because it violates the U.S. Constitution, B. Allowed, because such signs can be disruptive, C. Not allowed, because realtors are an important component of the economy, D. Allowed, because it applies to everyone equally. Correct answer is A. Not allowed, because it violates the U.S. Constitution. The posting of a for sale sign is generally considered commercial speech, which is protected under the First Amendment of the U.S. Constitution. While commercial speech can be subject to some regulation, outright bans are often deemed unconstitutional. The Supreme Court has addressed this issue in cases like Linmark Associates, Inc. versus Township of Willingboro, 1977, where it struck down a municipal ordinance prohibiting for sale and sold signs. The court found that these bans restricted truthful housing information and were not a permissible way to prevent panic selling and maintain integrated neighborhoods. There might be some very limited exceptions. For example, a community might have restrictions on the size or placement of signs, but a complete ban on for sale signs would likely be considered a violation of free speech. Question 495. Which of the following refers to deferred maintenance? A. An apartment building with a leaking roof, B. An apartment building lacking good views from its windows, C. An apartment building with poor Wi-Fi reception, D. A commercial building with newly installed plumbing. Correct answer is A. An apartment building with a leaking roof. Deferred maintenance refers to necessary maintenance or repairs on a property that have been postponed or neglected over time. A leaking roof is a clear example of a maintenance issue that, if left unaddressed, can lead to further damage and deterioration of the property. Poor views are a characteristic of the property's location or design, not a result of neglected maintenance. While frustrating for tenants, poor Wi-Fi is typically a technological issue or a lack of infrastructure, not a failure to maintain the physical property itself. Newly installed plumbing is an improvement or upgrade, the opposite of deferred maintenance.